All right, I promised you we're going to talk about data protection. If you guys are worried about data protection, then you're doing the right thing. If you're not worried about data protection, you may get caught out, and this is going to be a very important session for you because data protection is no longer something that you can ignore if you're a European operator. We have Dave Clancy, who's going to be joining the panel with Natasha Longson, and she's the enforcement manager at the Independent Commissioner's Office. Ladies and gentlemen, we'll start our session.
Okay, good afternoon. Thank you very much for attending this afternoon's seminar. I'm here to talk to you today about data protection and if your organisation is at risk. Despite the typo, I'm actually from the Information Commissioner's Office and my name's Natasha Longson. As mentioned, I'm an enforcement manager and I work on the anti-spam team, which deals directly with direct marketing. So what I'm going to cover with you today is in regards to the legal standards around managing user data, terms around email and SMS messaging and personal data use, and key measure affiliates must have in place. As mentioned, I've got my colleague with me, Dave Clancy, who's also an enforcement manager at the ICO. So, what does the law say? So, the aim of this session is to talk to you about data protection, but also to talk to you about the privacy and electronic communication regulations. And the reason I'm going to talk to you about both pieces of legislation is they're really tightly interwoven. So in one point, you've got data protection, looking at fair processing. Have you got consent from individuals to market them in a specific way and process their data in that way as well? And I'm also going to talk to you about the privacy and electronic communication regs, looking at the law surrounding specifically direct marketing, and that covers all aspects, whether it's live and automated calls, email and SMS messaging as well. So we do consistently see high levels of complaints in the gambling sector in regards to SMS messaging, and it is an area of concern to both the ICO and the Gambling Commission. So what does the law say? So under PECA Reg 22, that specifically relates to SMS and email messaging, and it relates to individual subscribers, and it talks about the transmission of the message, so basically who's instructing the message to be sent, in other words, who's benefiting from it, and it also talks about the instigation of the sender of the message as well. So who is actually sending that message out there. And what it requires for Reg 22 to be achieved is basically consent from that individual to receive direct marketing in that manner. So if you haven't got consent, then you can't send SMS and email messages in that way. So we know that many operators use affiliate organisations to send text messages on their behalf, and possibly this could be seen as a bid to avoid the regulations. It's not uncommon that we've heard arguments where not necessarily operators but organisations in general will try and blame the affiliates for sending out the messaging, and they have absolutely nothing to do with it. It's a responsibility of the data controller to ensure that they and anyone else they use, whether that's affiliates or third parties, are compliant with data protection and PECA regs. So you'd think on that basis that the focus is very much on the gambling operators as a data controller to make sure that they're compliant, which might make you think also that, given my nice picture up there, it allows affiliates to pretty much free of any compliance checks. But the reality is that affiliates are very much responsible for the data as much as the gambling operators. They've got requirements under data protection in terms of, as I say, consent, looking at the provenance of the data, having an audit trail of where they're getting that information from, and they've also got obligations under PECA as regards to the senders of those messages. So as I say, we are we do see an increase in blame to the affiliate organisations, but equally that's not to say that the affiliates are off the hook. You still have a responsibility there to comply with the legislation. So the downside to that, obviously, is if you're not doing, there's negative business implications with that. So if you can't demonstrate as affiliates due diligence and compliance, then obviously there's the potential for reputational risk, which obviously could then go on to lose your customers. And effectively, you could well be in breach of data protection and the PECA regs. On that note, obviously, it's a vicious circle. It could lead to bad publicity. And in terms of outcomes, there is a potential that you could end up with a civil monetary penalty of up to £500,000. So in terms of things to consider on that note, I've split it down into kind of what is going on and what the reality is. So, you know, in truth, yeah, we know affiliates will often use third-party data. It's not enough to say, you know, we might market you in regards to selected third parties. Third parties need to be very specific, and it needs to talk about the identity of the organisations, and at the very least give a detailed description of the products that's likely to be marketed that way. And if you haven't got that, and if you haven't told the individual that that's what's going to happen, or the third party hasn't done that, then it's not going to be valid consent. The reality is, as say, Reg 22, it states that a specific opt-in is required. And if you haven't got that, again, it's going to be issues in terms of your compliance with the legislation. So the next thing to look at is most affiliates won't allow access to the data list. We understand you don't want to get cut out. You don't want the gaming operators to go directly to the source of the data. But obviously it's a balancing act for operators as well, because they've got to screen against self-exclusion lists under the Gambling Commission's licensing conditions. And the Data Protection Act requires the organisation demonstrate due diligence. So the question is, how can operators comply with their obligations to screen against the self-excluded list if affiliates won't let them have access to their data? What we are seeing is a bit of a turn in the tide with this, and slowly the message is getting out there. Affiliates are recognising, and not just in the gambling sector but across the board, that actually there is benefit in letting your customers see your data list because of the pressures of legislation and the requirements involved. And we are slowly starting to see that, and going forward, that is really where it's going to end up. So finally, yes, affiliates are responsible for your data list. You've got responsibilities, as I've mentioned, under data protection and under PECA, but equally operators are also responsible for their affiliates, and that's when we need to see audit trails. Certainly if the ICO came knocking on your door and saying where you got your consent, we would be expecting to see where that's come from and how you've audited that, and literally you can demonstrate valid consent. Okay, so there was, well, it's not that recent anymore, but there was the Optical Express case versus the ICO, and the outcome of that was the tribunal basically said, in order for organisations to be able to send marketing messages, that the organisation must be named, or the specific description of what they're advertising must be named, otherwise consent is not valid. The decision wasn't appealed, so there is no case law in that, and obviously as the ICO we would welcome that, because that's what sets things apart. But to illustrate this a little bit more, we've recently, as of last week, we found two organisations, one for selling the data and the other for actually sending the data. So action will be taken. You are, as I say, I can't stress enough that the avoidance of responsibility just doesn't exist. So in terms of changes to the law, there's a lot going on. You may already be aware. There's much bigger implications for organisations coming up. Previously, we've seen loopholes where organisations have basically Phoenix themselves. So as soon as they start kind of being aware that there's things going on, they'll liquidate the company, and then several months later they'll set up again and carry on from where they left off. As of April, May this year, that will be a loophole that will be closed when directors' liability kicks in, and that will make the directors personally responsible. Also, May 2018, we've got the GDPR coming in. So this is a really good time in the period up to that time to basically get houses in order, make sure your data's clean, make sure you've got valid consent in place. And with GDPR, what we're finding is that the definitions of consent are much narrower than they are now, and that it will be an opt-in model. You will have to have opted-in data. And of course, from an enforcement and regulatory point of view, as I mentioned earlier on, at the moment we can fine up to £500,000. Come GDPR, that will change, and the fines will be up to 4% of your global annual turnover, or up to £20 million, whichever is the greater. So there's going to be much more at risk for organisations going forward. The e-privacy directive, in line with GDPR, is also under review, and certainly will provide updates as that goes on. And certainly, you know, we've got running a microsite off the ICO's website so that you can find out what's happening with GDPR and with the e-privacy directive. In terms of keeping in touch, we've got various social media sites that you can contact us on. But in terms of the day-to-day running of your organisations, if you have questions or you are not sure of the compliance, yes, we've got the website you can refer to, but we also have the helpline, and you can also contact the ICO for direct advice. And what I would say is if you are in any doubt, do get in touch with us, because if you're getting it from the regulator, you can't be going far wrong. So thank you very much for listening to me this afternoon. I'm basically open for questions now.
Hello? Yes. All right, thank you, Natasha. Thank you, Dave. Let's first start with any audience questions. Yes.
Hi, I've worked within the data industry for the past 5 years and have a full overview of SMS and email compliance, I feel anyway. If an organisation does, carries out the sufficient due diligence and has assurance or gets copies of opt-in statements, privacy policies, if a specific opt-in's in place for email or SMS, and the supplier has sufficient sectorised verticals in place to cover the nature of the campaign, is that deemed as being compliant?
If you've got all that in place and you can demonstrate that, then yeah, you will be fulfilling the requirements of the legislation.
Okay, thank you.
So in practical terms, what's the process when someone is not compliant? Are they first informed that they're not compliant? And then is there then a period for them to comply?
Okay.
What do you do in practical terms?
Okay, so we run kind of 3 different strands in terms of enforcement action. So if we become aware of an organisation that's not compliant, it might be that we can... Worst case scenario, you could end up with a fine, but that is a very worst case scenario, and certainly we would have done steps towards that. So we'll write to the organisation, talk to them about what it is, find out where they're getting the data from, where they think they've got valid consent, and we will go through periods of compliance and monitoring. So it might be that we get them in for a meeting and discuss where it is they're falling down, and basically give them ideas of how they can basically get compliant and improve their processes. If we saw that there wasn't a sufficient improvement over a period of time, then we could put them on monitoring for a given length of time. In those cases, we can publicise the organisation and say we've got concerns about them, and as I say, ultimately, if there's still no improvement, it could end up in a civil monetary penalty.
So, okay, so it'll be a civil matter at that point, but there's director's liability as well coming into play.
Say again, sorry.
You said there's director's liability coming into play as well.
Yes, it is. It come April,
Now,
May.
how exactly will that work? What will the directors themselves be limited to in liability, or is it an unlimited
We are
liability?
waiting to find out.
Okay, but something's going to happen.
Yes.
Great. Some more audience questions.
Hi, thanks for the
Hi.
talk. There are many data suppliers hovering outside, maybe some in the room, or hopefully some in the room. Is there a way where the ICO can work with the DMA in order to get these data suppliers a PECR license? Because they're all claiming to have PECR or lawful data that's fully PECR compliant, but actually when you analyse it, some of them aren't.
Okay.
Can there be a license? Like, for example, if someone's fitting my boiler, they have to have a boiler license.
Yeah.
If, in my opinion, if someone is selling data, surely there could be an ICO license that would help clear up this so that people know exactly what is PECR compliant and lawful and what's not.
Yeah, okay. Well, it's a good idea. Obviously, as you know, it doesn't exist currently. It'd be for the government to legislate on that. We can't make that decision because obviously we basically deal with the legislation as it stands. So it'd have to be lobbied through government. But it does seem a good idea in which to do that. But obviously, as technology changes and develops, what happens is the legislation needs to change and develop alongside it. But that certainly might be a way forward.
I just want to, is there going to be a section on the site that outlines exactly what is PECR compliant and what's not? Because I find when I'm asking different people, they're all interpreting it very differently. And I don't understand why there's that misinterpretation.
No, yeah, I'm at a loss too in regards to that, because out of the two legislations, PECR is much more black and white about what you can and can't do. There's a checklist on the ICO's website which literally really kind of dumbs it down into what you can and can't and what you need to do to be compliant. But in terms of outline, I mean, obviously, as I say, with the E-Directive being under review, there'll be constant updates on that. And that obviously will develop PECR as it stands at the moment.
Perfect, thank you.
I have a couple of Slido questions. As an affiliate, I pay marketing companies to do SMS drops with their data. They won't give them their data, and or send it to operators. And he's saying, can I no longer do this? So if he's giving an SMS company the right to go after their clients who have consent to get or claim to have consent to get SMSs from them.
Yeah.
And he's asking, can I no longer do this if I can't verify the data myself?
Okay, so as I say, consent has to be very specific. So when basically they'd be classed as a third party. So if the third party has got consent, naming the organisation they are going to be promoting, or a description, and it's not enough, as I say, to just say general gambling organisations or gambling products. It would have to be much more defined than that in terms of the description of what it is the marketing is going to be tailoring to. Then if they've got consent for those specific things, that would be fine. But if it's just a generic, that they've just got a general consent, not necessarily for that specific operator or for that specific type of product, then the chances are that they're not going to be able to.
But what if you had consent to send bonus information about online casinos, for instance? I mean, would that be specific enough? I'm an operator. I run an affiliate website. I'm going to send you bonus information every week of the best bonus. Can I do that?
So it would
I can't tell you what site it's going to be from because I don't know what it is next week.
But if it's about if that product description is very narrow, rather than it just being general casino, if it's very narrow to that precise thing, then yes.
Well, here's another question. I'm a gambler, and I want information generally about casinos. How would I get that?
So you're.
Let's say I'm a customer,
Okay.
and I want to opt in to get generally casinos. It sounds like it's making it almost impossible to get general information.
No, because it's direct marketing we're talking about. So if you're a gambler and you want general information, then that's up to the individual to go out there and find it. If you want to welcome direct marketing from whatever gambling site, company, affiliate, whatever, then you put your details out there. That's your will, if you like. That's your consent in doing that.
Okay. I had a question also regarding some letters that were sent out a couple of weeks ago
Okay.
to affiliates and marketing companies.
Dave will pick this up.
And let's see. Well, I have 3 questions about that. One says, well, you're checking them. Are they going to be up on the thing? Here we go. Okay. What was the real purpose of the recent letter sent to affiliates accusing them of sending spam text messages without any specific evidence? Your recent letters ironically spam the industry. Do you think this was against your own regulations? And let's see, I think there was another one all about the recent letters. Microphone 4, please.
Yeah, the letters that were sent out to the affiliate industry under Operation Mandara were directed at organisations which had been identified, perhaps wrongly, by negotiations we'd had with the Canadian authorities as being affiliates for income access, and that's in the public arena. We sent those letters out on the belief that these organisations had been identified as sending out SMS messages on behalf of online gaming companies. It transpired that a large proportion of those organisations that received those letters were actually affiliates that were using things like banner ads, social media, etc. There was a proportion of organisations that did SMS and email marketing. We've learned a bit from that, but I think what it has done is identified to the affiliate industry that there is this crossover now between responsibility for marketing between the gaming companies and the affiliates. The gaming companies like to distance themselves from the actual marketing themselves by saying, that's nothing to do with us, we don't market to these people. We say incentivise marketing on behalf of gaming companies means the gaming companies are responsible for initiating the sending of those messages. The affiliate who sends out the message will be the sender. So you can have one message and 2 responsible organisations. And we say that is an interpretation of the regulations that we will follow because we believe that's correct. Now we've pushed that message out to the market, to the industry now should be aware that there is this regulatory environment now that is taking responsibility for the affiliate industry, whereas before no one appeared to take any action or any notice of the affiliates because they were based offshore, no one was sure what the relationship was. So in a way, the mistakes that came from Operation Mandara have highlighted to us where the problem does lie. We've looked at the industry. The industry is now looking at the ICO, the Gambling Commission, as regulators and what can we do. So ultimately, it may mean that responsible affiliates get more trade from the gaming companies because they will identify that the affiliates that are just spamming people are creating a problem for the industry. And that's going to ultimately mean there's potential for penalties against the gaming companies, and they will start shopping around.
Now, let me ask this a final question. What is your extra territorial reach? Will this legislation extend beyond Britain, beyond the EU? Do you have reciprocal agreements in place with countries that license online gaming or affiliates?
It's a very complex legal environment that we're in because you can have, in effect, a UK gaming company or a UK company that may have, in effect, a gaming arm that's offshore for tax reasons, but they may have an establishment in the UK, have some office or establishment where they've got something in the UK. We will say if it's offshore, but they've got something in the UK, we can look at the Data Protection Act, which gives us a gateway to take action against them. If they are offshore and there's no legal gateway for us to take action, we will go to offshore regulators and say, what is the law in your land? The company is based in your jurisdiction is causing a problem for us, therefore can your legislation apply? And we at this moment in time speaking to regulators in the Channel Islands, Gibraltar, Malta. We can also go further afield and look at other regulators, as we did in the Mandara case, and we asked the Canadian Radio and Telecommunications Commission to act on our behalf to ask certain questions. So it's a worldwide problem, and regulators worldwide are now looking to work together with each other to identify the bad players in the industry and take action where we can against them.
That was going to be the last question, but I like this one that just came in. How do the regulators view data historically acquired pre-PECR? Do I need to obtain a fresh opt-in data, or is their old opt-in sufficient?
If you rely on opt-ins, which are pre-PECA, which are in effect 15 years old, that's going to be a no-no. What you've got to look at is your consents have got to be valid, they've got to be recent, within the last 12 months. It may be you can reaffirm consent, but it will be after quite clear what you're doing. And in relation to electronic marketing, if you send a message out to someone who's consented to receive messages from you, and you've got the relevant opt-out mechanism within that message, that's sufficient. If they don't exercise the opt-out, consent will continue.
Okay, thank you very much. If anyone has any more questions, please feel free to grab these two and ask them. Or, as we've said before from Natasha, go to the ICO website or contact them directly. A round of applause, please. Thank you for clearing all that up.